Call the meeting to order. Bienvenue à la réunion numéro 10.
Welcome to meeting number 17 of the House of Commons Standing Committee on Access to Information, Privacy and Ethics. Pursuant to Standing Order 1083H and the motion adopted by the committee on Wednesday, September 17th, 2025, and the order of reference of October 28th, 2025, the committee is resuming its review of the Conflict of Interest Act.
I would like to welcome our witness today from the Office of the Prime Minister. We've got Marc-André Blanchard, who is the Chief of Staff to the Prime Minister. Mr. Blanchard, I understand you would like up to 8 minutes to address the committee, so I'm going to give you that. Go ahead, sir. Please start.
Merci, Monsieur le Président. Merci de
Thank you, Chair. Thank you for giving me the opportunity to appear today in order to speak about my responsibilities as Chief of Staff and as an administrator of the assessment tool that was decided upon by the Prime Minister and the Officer of the Ethics Commissioner.
Canadians elected Prime Minister Carney at a moment of economic volatility, geopolitical realignment, and growing pressure on democratic institutions. Canadians chose Mark Carney as Prime Minister because of his deep experience in both the public and private sectors. In fact, they did not elect him in spite of his vast global private sector experience, but precisely because of it. Canadians understood that if we are to build a stronger, more resilient economy, one worthy of being the strongest in the G7, this experience is not optional, it is essential. A key condition for this government's success is public trust. At the heart of that trust are the high ethical standards the Prime Minister set for himself and for everyone who works with him in his office and across government. Part of protecting that trust is ensuring the ethics screen agreed upon by the Prime Minister and the Ethics Commissioner is implemented, always erring on the side of caution. An important part of my role as an administrator of the screen is precisely to ensure that the Prime Minister is not put in a situation of conflict of interest. Comme vous le savez, l'écran éthique est une...
As you know, the ethics screen is a compliance measure that was created under the direction of the Ethics Commissioner and is compliant with the Conflict of Interest Act's requirements. The main goal of this screen is to prevent conflicts of interest before they arise. It is a mechanism to identify and redirect the questions that come into the categories established by the Ethics Commissioner. This is an administrative mechanism and a procedural one that is based on the principles of transparency and integrity as set out in the Act. These ethics screens are often used in commercial and legal areas and is an efficient way to manage potential conflicts for people who work for government.
Reasonableness of the application of ethical screens in government, the Federal Court of Appeal confirmed, and I quote, "This practice of publicly identifying the potential conflicts of interest of each public office holder before any problematic situation has occurred strikes me as an eminently reasonable way to ensure the furtherance of the Act's purpose." End of quote. The Conflict of Interest and Ethics Commissioner has determined that a blind trust combined to a conflict of interest screen are the appropriate measures for Prime Minister Carney. When appearing before you, the Ethics Commissioner confirmed that the Prime Minister divested himself of all his interest in a blind trust. The Ethics Commissioner further added, to avoid a situation where he would make a decision knowing that it would increase the value of one of the companies he divested from, we set up a screen. It is in this context that the Prime Minister and the Commissioner have agreed to a screen as a preventive and appropriate measure of compliance. The Clerk of the Privy Council and myself, as the Chief of Staff of the Prime Minister, are the administrators of the screen. On this issue, I want to refer you to what the Commissioner said to this committee in response to a question asked by Mr. Cooper. The Commissioner then said, "Let's be practical. Anything that goes to Prime Minister for decision goes through either one of these men or both. They are, in effect, the key holders of what gets on his desk and what he deals with. They are the logical ones to make sure he does not get involved in these things. End of quote. It is important to underline that my role is first and foremost about ensuring that conflicts are prevented. The administration of the screen is a responsibility I approach with utmost seriousness. Dans la pratique, les bureaux du Conseil privé et du Premier ministre communiquent.
In practice, PCO and PMO are constantly communicating. Even if some meetings can be organized without the direct participation of PCO, no official policy can be adopted without the participation of both sides. The screen is administered by PCO. When a department or an organization prepares a briefing note, a proposal, or any other document for the Prime Minister, this document is first assessed using the evaluation tool that was created by PCO with the assistance of the Ethics Commissioner. This tool allows us to determine whether or not the screen needs to be applied. Those who are responsible for governance at the Privy Council do a diligent verification and ensure that all of the relevant information was factored in. Their recommendation is sent in to the Clerk of the Privy Council for assessment and approval. Once the Clerk has confirmed his position, his office shares it with me to seek my agreement. When both administrators are in agreement, the decision is sent to Privy Council governance.
From the public service have been jointly confirmed by the clerk and by myself. For negative determinations, where the screen does not apply, no further action is required by departments or agencies. For positive determinations, departments must clearly identify the material as subject to the screen. These documents are not shown to or discussed with the Prime Minister. The screen is applied on a precautionary basis. As soon as analysis indicates there may be a triggering factor, access is restricted pending the final determination of the administrators. Je tiens à souligner que le système actuellement en place pour éviter.
I would like to say that the system is in place to ensure that the Prime Minister does not end up in a conflict of interest. And this is one of the most rigorous processes I have seen in my career. It is proactive and preventive, and it is extremely rigorous because of the high level of sensitivity at government. Thank you, Chair. I'm ready to respond to your questions. Thank you very much for your opening remarks, Mr. Blanchard.
Minute rounds. Mr. Barrett, you have 6 minutes. Go ahead, please.
Has the Prime Minister provided you with a full list of all of his investments with Brookfield?
No.
How are you able to, do you have the list?
The list, I have the list that is, I'm as the administrator to the wall, the ethical wall. I am responsible for the administration of the wall as agreed upon by the Commissioner of Ethics and the Prime Minister. So the list that I obey from is the Annex A to the public declaration made by the Prime Minister.
So do you have full visibility on all of the investments in the Global Transition Fund and all of Brookfield's investments?
As I said, the Commissioner of Ethics and the Prime Ministers have agreed that actually the appropriate measures for the Prime Minister upon his election was two things: that he would divest of his investments through a blind trust, and that actually, as an additional preventive measure, an ethical wall would be set up. And there's a list at the Annex A of the companies that actually are, in a preventive way, could be the object of a wall if necessary.
A couple of things, sir. First of all, when Canadians hear that the Prime Minister has divested, I think that what they expect is that there's been a sale of those controlled assets. I appreciate that within the laws it's currently written that placing them in a blind trust satisfies that requirement, as that's what the Ethics Commissioner has said. However, the funds like the Global Transition Fund and future payments to Mr. Carney based on the performance of Brookfield create a scenario where it seems to me that the only way you could effectively ensure that the Prime Minister isn't making decisions that benefit Brookfield or himself financially would be for you to have the full list of the investments and interests in the Global Transition Fund and in Brookfield's portfolio.
I'll just refer you to a comment made by Nigel Wright in front of this committee, and Nigel Wright, who was the Chief of Staff of the Prime Minister, and where similar measures were applied in his case. There were actually, he had to divest of his assets in a blind trust, and there were 40 companies that were screened in that context. It's kind of the similar measures that we see here. And at the time, Mr. Wright, who became the Chief of Staff of Prime Minister Harper, said, he talked about his blind trust and about the blind trust. He said that the blind trust follows a form that was created and drafted by the Ethics Commissioner, as in the case of the Prime Minister here. He said, I transferred all of my control assets in the blind trust in late October. The blind trustee is the legal owner of them all now, and I'm not to have any communication of any sort, no direction, no advice, no information about what's in there. I do not know and will not know what's in there. Once a quarter, I'll be told what the value of it is. So he said there's a direct link between the Ethics Commissioner and the blind trustee, so that the Ethics Commissioner office will have the ability to know what's going on. But the purpose of the blind trust is to remove me and any knowledge I may have about my controlled investments and have them administered by a third party. It's exactly the same kind of situation that you have with Prime Minister Carney.
If I may, sir, I appreciate that it may be similar, but the Chief of Staff to the Prime Minister is not the Prime Minister. And the Chief of Staff to the Prime Minister does not have the ability to take the decisions and does not have the influence that the Prime Minister has. The situation also appears to be different because with Brookfield's investments in, all of the things that the government is committing major government spending to, whether it's artificial intelligence or modular housing or heat pumps, the Prime Minister's future payments depend on Brookfield's performance. And that's not something that's going to be sold by the trustee. That's something that went in and something that's going to come out looking the same way. The Prime Minister knows what he put into and what the investments were of Brookfield when he was chair at Brookfield Asset Management. He created the funds that he's going to benefit from based on their performance. Canadians are the ones who are in the dark about the decisions that the Prime Minister is taking and how they're going to impact his potential future compensation. So it's a lack of transparency that gives rise to this concern. And my recommendation, I don't come with a problem without a proposed solution. And would you not say that in this situation, it would give Canadians the confidence that they can have that the decisions aren't being taken with the perception of personal financial gain if the Prime Minister, if anyone holding the office of Prime Minister were to divest it by selling before taking decisions instead of placing them in a blind trust where they're still able to know what they put in.
We're going to have to come back to that, Mr. Blanchard. Mr. Barrett, I invite you to ask that question again in a later round or get a response to it. Madame Lapointe per 6 minutes. I'm going to be sticking to the time. We want to make sure we get as many rounds in as we can. Madame Lapointe pour 6 minutes.
Merci beaucoup, Monsieur le Président. Bonjour.
Thank you, Chair. Hello, Mr. Blanchard. Welcome to our committee. In your opening remarks, you talked about your role as Chief of Staff and as one of the administrators of the ethics screen. Can you explain to our committee why you chose to take on those roles and what do they consist of? I accepted these roles that were given to me by the Prime Minister and the Ethics Commissioner. And as I said in my opening remarks, The Ethics Commissioner believes that an ethics screen is a preventive measure. The goal is to ensure that the Prime Minister does not find himself in a conflict of interest. And in order to ensure that the screen is efficient, the people who are responsible for its application need to be aware of what's going on, both on the political side and for the public service side. That's why the Ethics Commissioner, when he testified before the committee, explained his decision in such a way by saying that people who are administering the screen need to be aware of what's being put in front of the Prime Minister so that things can be stopped if needed. Somebody external could not play that role. Thank you for that clarification. How did you ensure that the Ethics Commissioner is satisfied with the application of the ethics screen? We have discussions, regular discussions with the Commissioner's office. I spoke to the Ethics Commissioner when I arrived in this position and with the Clerk of the Privy Council. Our teams as well were in close communication with the Office of the Ethics Commissioner, and they continue to communicate frequently. The Ethics Commissioner is there to advise us and to confirm our decisions made in the application of the ethics screen. Up until now, is the Commissioner satisfied with the process that was implemented? Does he believe that things are sufficient? Up until now, and I can't speak for the Commissioner, but from what I've understood, he seems to be satisfied with the administration of the screen. I can give you an example. The assessment tool for the application of the ethics screen for the Prime Minister, and this is a tool to assess individual situations that are flagged by members of the public service or my office. Well, this tool was developed and was something that was discussed in depth with the Ethics Commissioner, and he is satisfied with the assessment tool that we use in order to make relevant decisions. The goal is always the same. The goal is to ensure that the Prime Minister is not placed in a conflict of interest. That is important for the Prime Minister and for our institutions. And so efforts are being deployed to ensure that we can succeed at that goal and follow all of the measures that were implemented. And we work closely with the Ethics Commissioner. Now, regarding the tool that you mentioned, it's the same tool that the Clerk of the Privy Council shared with us yesterday? Yes. So you fill out the boxes. So there are questions. There are 7 questions. And the questions, according to the answers, tell you what to do. And it gives us a more systematic approach for our decisions. When we're talking about ethical measures, my role is to ensure that people are aware, that people that need to be informed are informed regarding the measures. So that's deputy ministers for the different departments, and we also need to identify questions from the 6 categories that are found in the assessment tool. And of course, we need to have means to have advice and to work with the Ethics Commissioner's office. Thank you, Ms. Lapointe. And Mr. Blanchard. Mr. Thériault, you have 6 minutes. Thank you, Chair. Welcome, Mr. Blanchard. It's a pleasure to meet you. It's always interesting to meet a chief of staff, and I see that there are a lot of people in the room here today, and it's not for nothing. It's always interesting to get to meet the chief of staff as members of parliament. Yesterday, I asked a question to Mr. Sabia regarding Bill C-15 for the budget that was tabled 2 days ago at the House. I mentioned the tax credits for small nuclear power plants. At page 91, there is a tax credit that existed 2 years ago, but it did not focus on nuclear power plants, but C-15 adds a tax credit for these small nuclear power plants. In C-15, there is also a new credit for clean energy, and that also includes nuclear power plants on page 120. In that area, there are 5 major players, and one of those is Westinghouse that belongs to Brookfield. In your tool, and I looked at this tool yesterday on page 3, it states to those that need to apply it to pay specific attention to Westinghouse, which belongs to Brookfield, correct? Now, was the Prime Minister a part of that decision? Did you apply the screen? You can understand that given the nature of discussions, yesterday the clerk of the Privy Council brought up 6 decisions that were made regarding the application of the screen since its implementation. That's not what I'm talking about. I'm asking you about C-15 regarding the tax credits that were added for nuclear power plants, because I do have other things to say on that. Perhaps I can ask my question in its entirety and you can answer? Yes. Well, if you don't want me to answer the way I was going to answer, then go ahead. You were talking about... Well, that's not what I'm talking about. He said to me that it was of general application. Because of that, the screen would not apply. When we look at your document, the definition of general application that's on page 5, it states that if the decision has to do with an indeterminate group of people or companies, the matter is of general application. But I don't think that 5 players is indeterminate. NuScale Power, Westinghouse, General Electric Hitachi, Atkins Rillick, and Technic at Home. On page 6, when we want to see whether or not it applies in a general manner, it's if it applies to a small group that is not a large category. And so that's a problem. Why did you not apply the screen? Mr. Sabia gave you the context. In his view, it was a general application and did not require the use of the screen. But I'm asking you the question today. I'm looking at your document. I don't need to repeat the question, I imagine. According to your document, you are not applying this ethics screen when you should have to that situation. I respect your interpretation. That's not your interpretation, that's your document. The process requires a lot of rigor, and for the application of this tool, you can see it. We look at the work that is done at the different departments. They carry out the analysis on the policies and the measures that could be subject to a recent or a decision. And then if a screen needs to be applied, we verify that by looking at the questionnaire. I understood that the people who did that analysis made a decision that the screen did not apply. Well, perhaps you were not able to comply with your document and you seem to have a lot of difficulty applying your own tool. Could you share with us the analysis that was carried out and which led to the situation in which it was decided that 5 players was of general application, that it was not a small category? And perhaps I can move on to another question. How much time do I have left, Chair? You have 35 seconds, Mr. Thériault. The Ethics Commissioner would like for us to extend the legislation to an apparent conflict of interest, and I would like to know if you agree with that. I don't have any position on that, and I believe that that's not what Mr. Sabia said. The Ethics Commissioner agrees. He's the one who proposes it. It's up to parliamentarians and up to the committee to do that, and I respect your work, and it will be up to you to decide. Thank you.
Go ahead, please.
Thank you, Mr. Chair. Thank you, Mr. Blanchard. Mr. Carney's conflicts involving Brookfield are vast by any objective standard. That is why the Ethics Commissioner saw fit to impose special compliance measures, including the ethics screen that you, along with Mr. Sabia, administer, which includes, of course, 103 companies, most of which are Brookfield related. Mr. Sabia, in his testimony yesterday before this committee, referenced that the Ethics Commissioner personally told Mr. Carney that he should not be meeting with Brookfield. Yet, on August 11th, only 1 month after the ethics screen was put in place, Mr. Carney was speaking with and taking photos with Sam Pollock, who is none other than the CEO of Brookfield Infrastructure, and who also just happened to serve on the board of Brookfield Asset Management when Mr. Carney was chair. So here we have the Ethics Commissioner telling Mr. Carney not to meet with Brookfield, and 1 month later, Mr. Carney is doing precisely that. How do you explain that, Mr. Blanchard?
Le Premier ministre du Canada est bien au courant de ses
The Prime Minister of Canada is well aware of his ethical requirements, and he follows them, each and every one of them. What was done by the Prime Minister, and after talks with the Ethics Commissioner, we implemented these rigorous measures to ensure that there are no conflicts of interest.
The Prime Minister was told specifically not to meet with Brookfield, and there he is meeting with Brookfield. Back up before that to April 30th, just 2 days after the federal election. According to the Lobbyist Registry monthly communication report, Mr. Carney was directly lobbied by North River Midstream Incorporated. Now, the Lobbyist Registry indicates that North River Midstream Incorporated, the parent company, is none other than Brookfield. So again, we have the Prime Minister directly meeting, being directly lobbied, this time on energy policy, by Brookfield. Again, not following the spirit of the ethics screen.
Il y avait des mesures éthiques qui étaient mises en place.
There were ethical measures that had been implemented at that time, between the moment where the Prime Minister became Prime Minister in March up until the conclusion of the measures that have been in place since July 10th. What I'm saying is, I believe that the Prime Minister met his ethical obligations during the period of time that you referenced. And since July 10th, the companies identified...
Terminer ma réponse,
Can you let me finish my answer, please?
I'm taking my
Mr.
time
Cooper,
back.
go ahead.
Then, on September 27th, while in London, England, Mr. Carney attended an intimate working breakfast with Canada's High Commissioner to the UK, Ralph Goodale, and 8 international investors. 4 of the 8 investors present were from companies that have major connections to none other than Brookfield. Just another coincidence? It seems to me to be part of a pattern. Brookfield, Brookfield, Brookfield.
Dans ce contexte-là, en fait, je pense
I believe that Canadians are quite pleased that the Prime Minister can meet with some of the greatest investors in the world. These are not businesses that are linked with Brookfield. These are independent investors. They are among the most significant companies, and we are seeking to reach investors in Canada.
You
I
had
would
equal
submit-
time, Mr. Blanchard. I'm
Point
going
of order,
to
Chair.
Mr. Cooper.
Point of order.
What's your point of order,
The
Mr.
point of order is that as MPs, we need to allow the witness to answer the question.
The
The member
witness
has
had
asked
ample time
a
to
similar
answer
question
the
multiple times,
question.
and it's not allowed the
not-
witness to answer.
The witness had ample time to answer the question. I didn't stop your clock. I'm going to add another 25 seconds to your time. I gave Mr. Blanchard ample time to answer the question. Mr. Cooper, it's your time. You have 45 seconds.
Well, you know, we've heard various excuses, various explanations offered. Technically, the screen might not have applied in these cases. Technically, there might not have been a direct conflict of interest. There's always some sort of explanation. But wouldn't it be better if the Prime Minister simply heeded the advice of the Ethics Commissioner and stayed the hell away from Brookfield? Wouldn't that be better?
Alors, est-ce que je peux répondre, Monsieur le Président?
15 seconds.
Can I respond, Chair? I just wanted to tell you, for all of the meetings in London, the measures were implemented and there were no issues with those meetings because these are among the most significant investors in the world and they're not directly linked with Brookfield. Thank you.
Thank you, Mr. Chair, and welcome, Mr. Blanchard. Let me take you back to your earlier statement about the exchange with Mr. Nigel Wright before this committee. Mr. Blanchard, would you be willing to provide a text of his appearance to our committee to be able to read it into the record?
Yes.
Would you be able to do that maybe within the following week?
Yes, I will.
Fantastic.
For sure.
One of the areas that my colleagues are interested in is around the notion of what constitutes a private interest and matters of general application, matters that affect a broad class of persons. How could you explain for us a little bit more about how you go about when the screen is in operation, determining when there is a matter of general application?
When there's a matter of general application, it applies to all Canadians or to all taxpayers or to all individuals. And the issue, so that's kind of the definition, the very broad definition of this. And when you look at the document that was the assessment tool that was provided yesterday, they give you the tools and the threshold questions that are being asked in this context of the matter of general application. So, if it's a matter of general application, and if the answer is yes, then the matter is of general application, and this screen does not need to be triggered, and no further analysis is required. So then, if it's no, then we go to the next question, and this is where we look at, so it's not of general application, is it of a broad class? And then we go and analyze if it's in the broad class, then does the company involved has a disproportionate interest or benefit in this environment?
And then what is the role of the Ethics Commissioner in working through this process with you? And how often would you communicate with the Ethics Commissioner in their office?
It actually, the main work, the day-to-day work of this assessment tool is performed by the deputy secretary to the Privy Council responsible for governance. And actually, her office is in regular consultation with the Ethics Commissioner office. And then on our side, on the political side, this is why I was answering and very happy to answer to Mr. Cooper previously that actually the meeting he was referring to in London, we had verified each and every one of those guests and whether they were could be part of a screen or not. And the answer was no, because none of them were related to Brookfield. Actually this, and then we went and had a discussion with the ethics commissioner on these issues. So this is how it works. So on the context of meetings, it's more on the political side that we have maybe the lead because this is how the request for meetings or the organization comes in. Then on the policy decision, it's largely done under the Deputy Secretary of the Privy Council responsible for governance.
That's a very good segue to a question I have about the specific process for screening out meetings and decisions to ensure that the Prime Minister is in compliance. Could you maybe take us through that a little bit?
So when a meeting is thought of or is being requested, there's someone who works with me, and that person is actually making a first check. Is it on the list of the Annex A? Is that company on the Annex A? And if it's on the Annex A, then there's no meeting. We go further. We say, well, for any meeting that occurs, we actually make sure that there's no mention of any business in relation to the government, between the government and any entities listed on Annex A. So there's a double check. The first is the identity, and then if it's a third party that comes in and wants to discuss a plan, an option, or something, a project that involves one of the companies on the Annex A, then it triggers, we say that the meeting cannot occur.
Okay. Thank you, Ms. Church. Monsieur Blanchard, Monsieur Thériault, je vais donner 5 minutes. Commencez, s'il vous plaît.
Mr. Thériault, you have 5 minutes. Thank you, Chair. 5 minutes? Mr. Blanchard, given the Prime Minister trying to be objective regarding his past and his current position, well, in reviewing the legislation, we are trying to have different rules for the Prime Minister and ministers. For MPs, it's already done, and we want to do this in order to build people's trusts in their democratic institutions. Mr. Sabia agreed with that and has brought that up elsewhere in his career. I'm not trying to catch Mr. Carney in a trap. I want to look at the situation at hand. We haven't seen a clerk have to divest in order to protect his prime minister because he had to apply an ethics screen. I think we can agree on that. So that's important to state. I asked the question to Mr. Sabia yesterday, and I'm asking it to you today. Do you know what is held in the blind trust? No, I do not. Because it is not part of the administration of what I have to do. My role is linked to the ethics screen and the companies listed in Annex A. That is what we are responsible for administering. What's in the ethics screen, and as I explained, as Nigel Wright also explained in his testimony, this is an area where the ethics commissioner can be informed of the content. So this is up to the ethics commissioner. So only the ethics commissioner is aware of the detailed content of the trust. Is that correct? I don't know what the content is. If I've understood, it's between the trustee and the ethics commissioner. And so you feel able to apply this screen. And that's possible. May I respond? I do believe that I can, and I am competent, because this is a measure that was implemented and chosen by the Ethics Commissioner to ensure that we could act preventatively to avoid any conflict of interest. That's why I feel comfortable applying this. And the Commissioner is an agent of government. I didn't need that part of your answer. I wanted to go elsewhere with my question, and my time is running out. Mr. Sabia yesterday was saying that there is daily collaboration with the Ethics Commissioner. I asked him if there needed to be some accountability, and he said no, because he's in daily contact with the Ethics Commissioner. It seems quite complicated to manage the Prime Minister's affairs when you have to communicate on a daily basis with the Ethics Commissioner. Would it not have been simpler for Mr. Carney to divest, as Mr. Sabia did? It was his choice. But would it not have been simpler? Because this is a criteria that we will be examining. As the Clerk of the Privy Council said to you yesterday, and as the Ethics Commissioner has said to you, you need to find a balance between attracting the best talent to politics and having ethical rules that follow the highest standards. Our ethical rules are among the best according to the OECD. And that's not nothing. Another thing that is worth mentioning, and as I mentioned in my opening remarks, Canadians elected Mr. Carney because of his background. That I understood in your opening remarks. I didn't want to ask you any questions on your opening remarks. Inaudible for the interpreter. Is it true that there is daily communication with the Ethics Commissioner? And if so, through whom? I imagine it's someone who works for the Office of the Ethics Commissioner. Should that person be a part of your team? A brief response, please. For PMO, it's not a daily basis for communication with the Office of the Ethics Commissioner. We communicate regularly. The time is up. The time is up. Apologies, Mr. Thériault and Mr. Blanchard. Mr. Hardy, you have 5 minutes, please. Thank you. Thank you, Mr. Blanchard, for being with us today. We're looking at the nitty-gritty, the details, but I would like for us to look at things more broadly. We talk about rebuilding trust in our institutions. We've heard that democracy is under pressure. People don't trust their democracies or their governments. In a crisis, what's important is transparency and also to overcorrect. And you talked about striking a balance. Do you think that it's important that Canadians understand that we're trying to overcorrect in order to rebuild their trust? In my opening remarks, I mentioned a decision made by the Federal Court of Appeal from 2018, and it was Democracy Watch and the Attorney General and the Ethics Commissioner. In that decision, what was interesting was that the judge, speaking on behalf of the court, and you'll have to excuse me for reading it in English because the text is in English. He says
may well end up providing more information to the public than the publication of recusals. So, alors ce qui je trouve intéressant là, c'est que
what's interesting there is that, and with that decision, the measures that are in place, the list of companies in Annex A, this is already showing a lot of transparency, and it's more transparency than the usual measures. Mr. Blanchard, you're giving me a politician's answer. No, I'm giving you a rigorous answer. Canadians are losing trust in their institutions, and every time we ask questions, we're told, yes, but there's this in the legislation, but people don't believe us. You stated earlier that you want to ensure that there's no conflict of interest for the Prime Minister, but I think the goal should be that people trust in their institutions, because if they lose trust because of our actions, well, that's a problem. We are here to represent Canadians, and when Mr. Sabia came here yesterday and said to us that in order to do honorable work and to not place himself in a problematic situation, he divested himself. And everybody agrees that that was a good thing to do. And you spoke about the Prime Minister as though he was a virtuous hero here to save the day for the country. But why did he not divest? Because this is an exceptional time that requires exceptional measures. There's a lot of pressure, and Canadians are seeing that the Prime Minister is simply getting richer. I quoted Nigel Wright, where there were investments in a blind trust and 40 companies that were part of an ethics screen. It represented something similar to the Prime Minister, and in my experience, the process works very well, and it's not very complicated. But the situation's not the same as 40 years ago. Well, Canadians trust Mark Carney. Well, that's not what we're seeing, because you're not in a majority government. There's a lot of people who did not vote for the Liberals. My next question is, how many hours in a week does it take? Mr. Sabia said that it was teams doing this full time. How many members of staff do you need to ensure that there are no faux pas for Mr. Carney? As Mr. Sabia mentioned yesterday, there are multiple people who are tasked with that. But is it 2 people working part-time or 100 people working part-time? That's different things. In my opening remarks, I stated that the screen that is applied for the Prime Minister is among one of the most rigorous that I've seen in my career. I was a lawyer at the head of a firm, and I worked with the Caisse de dépôt et de placement du Québec, and I had to apply many ethics screens. What will help these measures succeed is that people are aware in government of what the requirements are, and they can raise a red flag if there are any issues, and the situation is managed efficiently because of that. Mr. Sarri, you have 5 minutes. Thank you, Chair. Thank you, Mr. Blanchard. I would like to perhaps simplify our discussions for Canadians who are listening to us so that they better understand the screen and its application. This is important because we're talking about the trust of Canadians, and perhaps we can simplify the way we describe things. Can you explain how you would identify a file that would require the ethics screen? For the screen, we carry out an analysis. We get information from departments on the companies in Annex A. We look at the different sectors of the economy. We see if some were identified and in which those companies are active. And then we decide whether or not there needs to be more attention there. And we have a list of questions that helps us make decisions and we apply it to the different situations, and a conclusion is made by the department first, and then we talk about it at PCO. The clerk of PCO makes a decision based on the recommendation made by the secretary who had discussed things with the ethics commissioner. Once a decision is made, is the government apparatus made aware of it? Yes, and I mentioned this in my opening remarks. As soon as a flag is raised, if the deputy secretary at cabinet and PCO, the one who's responsible for governance or administration, well then measures are applied immediately so that we prevent a conflict of interest. If I want to explain this really simply, the Prime Minister divested. He agreed with the Ethics Commissioner that there were companies with which he needed to avoid participating in decisions on. There's an annex with that list. We ensure that we do things in a preventive manner so that the Prime Minister is not put in a situation where there is a conflict of interest. It's not that the Prime Minister is in a conflict of interest. We want to ensure that he does not find himself in one. Yesterday, Mr. Sabia was here, and we asked him, how frequently do you meet with him? For me, every day. No, regarding the screen. We speak to each other frequently about the screen. But as I mentioned earlier, he and I know the companies, we know the subjects, we know when a red flag is raised. There are meetings to follow up. And we have ongoing discussions. And a more personal question for you. You are a representative for Canada, and you are responsible for Europe, Asia, and you're responsible for a large firm of lawyers. Can you tell us about times in your past where you've had to support independence? You have 20 seconds. Independence. Well, there are rules that are very important, and the culture of these businesses that is also important. Rules are necessary and essential, but we also need to ensure that there's an ethical culture that is developed. That is why I like the mechanism and the tool, because it helps us to develop that culture in government. Thank you, Mr. Blanchard.
Concludes our first hour. We're going to take a little bit of a break, and then when we come back, we're resetting the clock. And just a reminder that the time that we're suspended adds to the time at the end, so let's make sure we get back as soon as we can. Meeting is suspended for a few minutes. We're going to start the second hour with our guest, and I'm going to begin with Mr. Majumdar for 6 minutes. Go ahead, sir.
Thank you very much. I really appreciate your testimony today, sir, and I understand that politics and business can be sometimes a messy business. And the point of ethics screen, ethics standards, the Conflict of Interest Act, is to try and ensure that the public interest is best served, as you well know, that public officials serve with integrity. Some comments were made about Mr. Wright. I've known him. I knew him a long time. He is one of the most ethical people we know. The firm he represented was much more narrowly focused than the firm that Mr. Carney came from, which is very broad, affects a variety of sectors across the country. So I think it's a very different standard for the Prime Minister who decides versus a very senior advisor who advises. In the United States, the expectation of public office holders is to force their officials to sell all their interests and give a very attractive tax rollover so that there would be no suspicion of conflict, which is something that the clerk of the Privy Council did, but the Prime Minister clearly had a different idea for himself. So in the context of what is the formal process for screen versus the informal process for screening, we're really trying to get in this committee down to the nub of where the general application ends and where a disproportionate interest begins. Now, listen, I say this with great affection to those who serve, but Mr. Sabia, Mr. Carney, Mr. Hodgson, and you, Mr. Blanchard, all know the same people. You come from the same investment world. You have many of the same friends. Who's screening who amongst each other here?
Vous savez,
I have over 30 years of experience, and I've always applied the high standards.
je vais juste vous dire que j'applique
I wanted to say that I personally apply the highest ethical standards in my role and in all my previous roles, whether it be for that law firm or as representative of Canada.
The kind of value that you provide to... Pardon, je parle français un tout petit peu, mais je suis un étudiant.
I speak only a little bit of French, but...
To the translator, but I'd like to say, who is screening who between the four of you? I understand all four of you believe that you are serving the public interest. You've come from on high to serve the people of Canada. We should be grateful, but this is a very small world of investment institutions. They all operate on major sectors that are critical to the success of Canadian workers. So among all of you, who's screening who?
Ce que je vous ai répondu très
I personally, and for all the people that you mentioned, these are people with irreproachable careers in both the public and private sector. And these are people who follow the highest ethical norms.
But rather an advertisement on their pedigree, which is really not what I'm interested in exploring with my time.
Point of order, please.
Mr. Speaker. Point of order. Go ahead, Ms. Church. I know what your point of order is.
Only that the question was asked twice, and on two occasions the witness has been unable to answer.
Okay. Mr. Blanchard.
I appreciate the question.
Are you able to directly answer Mr. Majumdar?
Sa question est pas reliée à l'administration.
His question is not related to administering the screen. But I'm trying to answer when we're asking who does the verification for who.
Monsieur Blanchard, attends une seconde.
1 minute, please, Mr. Blanchard. I stopped Mr. Majumdar's time. Mr. Majumdar asked you a question. Please ask your question, and I'll be restarting your time now.
I asked a clear question about who's screening who, including the Prime Minister, so it was directly related to the topic here, but we didn't get an answer twice. Look, Duff Conacher, the head of Democracy Watch, has described this Prime Minister as potentially the most conflicted in Canadian history. The most conflicted. He has over 100 conflicts of interest hanging over his head in every single decision he takes, in private, in cabinet, in meetings with public officials, and in accountability with the public. Now, every commissioner that has come before this committee has complained that the government hasn't resourced them enough to do their jobs. There's a cloud of uncertainty and of corruption over the Prime Minister in massive decisions from renewables to housing to energy to infrastructure, all things that he has not divested himself from, and in which we're not confident he is being appropriate with his disclosure. So is he trying to have his cake and eat it too, or are we being unnecessarily silly about moving, who's screening who, what's being listened to, without actually providing the kind of transparency Canadians deserve?
Monsieur Blanchard.
Je veux juste vous dire que
Democracy Watch, since we're trying to see who's saying what, the Federal Court of Appeal looked at Democracy Watch, and that was in a decision made in 2018, and I quoted it earlier. Those are the facts. Now, regarding what we're talking about and Mr. Carney's situation on the measures that need to be applied, they meet the highest standards in the world for ethical rules.
Were established by Prime Minister Harper and indeed Nigel Wright. A quick question. The Prime Minister declared on the floor of the House of Commons that he texts the American president. Who screens those texts?
il y a vous savez,
The Prime Minister imposes on himself the most stringent ethical rules, and in communicating with the President of the United States,
Context of an $80 billion deal that was made with Westinghouse
We'll have
is
to
there any
come-
way to actually understand what the Prime Minister did?
We will have to come back to that, Mr. Majindar. I'm sorry, time is up. Mr. Fergus, go ahead for 6 minutes, please.
Merci beaucoup, Monsieur le Président, puis merci beaucoup, Monsieur Blanchard.
thank you, Chair, and thank you, Mr. Blanchard, for being with us today. I greatly appreciate that you are here to respond to our questions. You quoted Nigel Wright earlier, and his appearance here at committee when he was Chief of Staff regarding the screen. You mentioned in response to my colleagues across the way that it's a comparable situation between Mr. Wright and Prime Minister Carney. Can you give us more details on the similarities between both cases? In that context, it was a company called Onyx that had important business in the Canadian economy, and Mr. Wright played a senior role. And just like in this context, there was the divestment of his assets into a blind trust, and following discussions with the ethics commissioner at the time, they had decided on applying an ethical screen that impacted about 40 companies in 5 sectors of the economy. So it's similar to the measures that are implemented. I have a lot of respect for Nigel Wright and what he did. And what I'm saying is that in that context, he was defending the process as being acceptable and normal in the circumstances, and that's why I'm drawing a parallel here with Mr. Carney. Since Mr. Wright appeared, it's the same system that's been in place, and it seeks to ensure that there are no conflicts of interest for those who have chosen to join our political system. The work is done with the ethics commissioner and with trustees This system has been around for more than 10 years. A lot more than 10 years, actually, that it's been applied one way or another. This system has been applied to many a politician. Divest into a blind trust, that's something that is frequently done. And for public office holders, there's also the ethical screen that is implemented and has been used many times in our government's history, whether it be a liberal government or a conservative government. And these were seen to be efficient measures and effective measures. Yeah, there seems to be no issues. It works well on prevention and ensures that a politician is not exposed to a conflict of interest. Yes, exactly. That's why I made reference to the decision by the Court of Appeal. You can have a recusal system, but it might not be sufficiently preventive. Here we're talking about a divestment, a situation between the Prime Minister and the Ethics Commissioner, and they decided to do more and go beyond divestment. They decided to create a list of companies at Annex A, and they agreed upon a mechanism in order to ensure that the Prime Minister does not find himself in a conflict of interest. The goal is to ensure that the Prime Minister is not in a conflict of interest. It's important for the Prime Minister, but it's also important for his institution, for the government, and for the government's success. Chair, how much time do I have left? Thank you. Your role and the role of the clerk of the Privy Council, how does that strengthen the independence of that process? We need to work on prevention. We need to be able to see decisions that are coming up and future meetings and avoid conflicts. That's why the clerk of the Privy Council and the Chief of Staff were given the mandate by the Prime Minister and the Ethics Commissioner to carry out this work. And the matter of independence, well, at the end of the day, it's the individuals that make a difference. It's the rigor and the rules that are implemented and respecting the ethical rules. If anything is missing from that list, you won't succeed. Thank you, Mr. Fergus. Mr. Thériault, you have 6 minutes. Thank you, Chair. Mr. Sabia yesterday was saying that there's daily cooperation. You're saying frequent communication. I asked what the frequency was, but anyway. Your accountability, is that done because you are constantly asking the commissioner whether or not you're on the right path? Does the Office of the Commissioner participate in administering the screen? The commissioner contributes to our analyses. So yes, in a way he does. This has been bothering me. That's why I wanted to ask the question to Mr. Sabia and why I'm asking you the question today. When I asked this question to the commissioner, and because I'm looking to find how we can make the process even more rigorous, I think it needs to be. You talked about Mr. Wright. He was not Prime Minister. When the Prime Minister knows that there's a minister that could be in an appearance of a conflict of interest, it can be managed, but it's not the ethics commissioner that's going to manage that. Who's going to manage the prime minister? Well, that's what we're talking about. So, when I was asking questions to the ethics commissioner, and I was asking about accountability and whether or not it should be his office that should be responsible for it, he stated, and I'm going to quote him, "I cannot be both judge and jury. If my office participates in the administration of this screen, I'm going to be the one making a decision in the case of a conflict of interest." And after hearing that it can be difficult to administer the screen, even though there's a process and a tool, even though the tool is not necessarily well understood by everyone, well, there could be some shortcomings. And in order to avoid that, you ask the commissioner whether or not you're on the right path, but then it's as if the commissioner was a part of your team full time. I would say that the commissioner gives us advice as we're going forward on our work. But was this tool developed after speaking to the commissioner? He validated it. We did discuss it with him, and I understood that he was comfortable with the tool. And if it's well applied, it would meet certain criteria. So we'll perhaps be able to solve the matter when we speak about it with the ethics commissioner. Did you apply a screen with Mr. Carney's communications on the companies that are in his disclosure? Is Mr. Carney banned from communicating with people who are on that list? Mr. Carney is well aware of his obligations. Did you apply a screen? Mr. Sabia yesterday was saying we don't ask him to recuse himself. We tell him. Did you tell Mr. Carney not to speak with Brookfield? Mr. Carney knows which companies are on the list on Annex A, and there's no screen necessary. But how do you control that? Mr. Carney comes from the private sector. He's very talented, that's right. But he's got an address book, and people can call him. Mr. Carney imposes the highest standards to himself. Well, he's applying the filter himself, the screen to himself. What I'm trying to say is for meeting requests and for call requests, they are sent to us, and we look at it considering his role, and we have a system, and it's linked to the implementation of the ethics screen. And as I said, if it includes one of the companies in Annex A, well, there is no commitment made. And if there's any with third parties, well, they won't talk about topics that would have an impact on companies at Annex A. So you didn't ban Mr. Carney from speaking with Brookfield. The screen is implicit. Well, the legislation requires it. I'm surprised that Mr. Carney could respond to any call. And that's not the case, Mr. Thériault. The interpreter regrets they're speaking at the same time. Don't forget about our interpreters, please. When you speak over each other, it's very difficult. I was asking the question to Mr. Sabia yesterday regarding Mr. Carney's trip to the Arab Emirates. And on the same day, Brookfield made an announcement about $100 billion towards AI. And it seemed like a strange coincidence. And whether the clerks saw that as being a coincidence. Apologies, Mr. Thériault. You're at time. I apologize. That's unfortunate. Unfortunate for all of us. Mr. Hardy, you have 5 minutes. Earlier, you stated that you had rarely seen such a solid structure in place, and you have a background, and you were at the head of many organizations, Mr. Sabia as well. Mr. Sabia was the equivalent of a prime minister for many organizations. The Caisse de dépôt de placement du Québec, you were at the head of that. Is it a similar structure? Did you have direct employees of management that had to ensure that their managers were not overstepping or making any false steps? Those who are responsible for the screen generally are from the legal office, and they report to the board, and they apply the screen. Direct employees. In that case, yes. For Mr. Carney, you are directly in discussion with him every day. Yesterday, he mentioned that there's independence. But how can you be independent but also be directly employed at the same time? You talked about the private sector. Let's use that as an example. A chair of the CEO would name the director. You see whether or not he's under the president of the board, but his main goal is towards the company and not towards the one who appointed him. And we can use the same analogy for me. I was appointed by the Prime Minister. There's no board that appointed you. It was the Prime Minister. It was the same analogy that I was making earlier. There's no board. That's the point I'm making. What I'm trying to say to you is that the chief of operations is independent, even though he's appointed by the president of the board. For the application of the screen, I am independent from the Prime Minister. My main focus is for the Prime Minister. Well, using your own logic, if Mr. Carney is not satisfied with the decision that was made, he could fire you. Well, there, I would say that my wife would be very pleased with something like that. Yeah, we've heard similar responses. You said this earlier. We're looking at the present, that you're doing everything to ensure that Canadians are protected. We're all virtuous. Mr. Carney self-regulates. At the Ethics Committee, we want to focus on the future. We want to ensure that our legislation can support people like you, like Mr. Sabia, like Mr. Carney. We want to future-proof our government, and we want to ensure, and we want to attract people like Mr. Carney, but we also cannot attract the wrong type of people. Mr. Warnick was saying that politics is a short time for someone's career, and Mr. Carney, Prime Minister Carney, comes from the private sector. We don't know for how long he'll be here, but when he goes back to the private sector after being Prime Minister, he can be benefiting from his current position, and we want to ensure that this is not a recurring event. Do you believe that with our current structure, we are attracting only the right people? Or is it possible that our legislation has so many holes that we attract the wrong type? I think that your comment towards Mr. Carney is unfair. He was a member of the Public Service of Canada. He was governor of the Bank of Canada. First governor of the Bank of England without being British, and spent a large part of his life in the public sector, more than in the private sector. So what I'm trying to tell you is that in the context of Mr. Carney, you have someone with experience in the public sector and in the private sector, and that private sector life was much shorter than the public sector. But what does that change in my question? I want to ensure that we attract the right people. I'm not making the analogy or a complete analysis of Mr. Carney. I want to ensure that the structure that we have is able to control people who might have the intention to do what he is doing, but with bad intentions. We can give him the best intentions of the world, but if somebody has bad intentions and it's the Prime Minister who can fire people who apply the screen, well, how is that going to build trust? Mr. Hardy, your time is up. Mr. Baker, you have 5 minutes, please.
Merci, Monsieur Blanchard.
Thank you, Chair. Thank you, Mr. Blanchard. I have a few questions for you. There are Canadians who are watching this meeting. And for their benefit, can you explain what the goal is of the screen and divestment? What are you trying to do? It's quite simple. We want to ensure that the Prime Minister does not find himself in a conflict of interest. We're doing this in a preventive way. It's one of the best practices that is recognized throughout OECD countries. This is something that has been applied many times at the Government of Canada. Mr. Carney is being treated the same way as many other politicians that we've had here in Canada. We have experience in managing this kind of case in the government apparatus. That's why we are meeting the highest standards in order to manage this kind of situation. And what you have in place, is it compliant with legislation? Yes, it meets all the conditions of the Act. What was put in place for the Prime Minister is something that was agreed upon with the Ethics Commissioner, and he's an independent officer or agent of government, independent from the Prime Minister. And the current Ethics Commissioner has a lengthy background in the public service. He understands government well, and he agreed on the measures that need to be applied to ensure the application of the legislation on the public service.
The screen design of the processes you have in place.
It is my understanding, yes. He is on the screen. It's not only my understanding. It's actually, I know this because I was in discussion with him on this topic.
And is he comfortable with the implementation of the screen?
And as far as I know, he is comfortable with the implementation of the screen. And as I said, is son avis, his advice, the advice of his office is sought along the way to make decisions on the on some of the in the matter of processing the application of the screen. And this is no different than for any other public holders, the détenteurs de charges publiques, alors public office holder. So it's everybody's treated the same. Mr. Carney is treated the same as any other public, any person who holds public office like it.
That's a good segue for my next question. One of the members opposite from the Conservative caucus mentioned that the current law was actually brought in place by Prime Minister Harper at the time of Prime Minister Harper, and in fact during that time there was a similar hearing with Mr. Nigel Wright, who was alluded to earlier in this hearing, and I just wanted to cite some testimony from one of the Conservative MPs at the time in questioning Mr. Wright. This MP said, "I just want to make a clarification, Mr. Chair, because there seems to be some misunderstanding in the way this has been debated by some members. On the term private interest, I will quote directly from the process for establishing a conflict of interest screen. Private interest does not include an interest in a decision or a matter that is of general application." So this Conservative MP believed that when there were decisions of a general application, that the private interest did not apply. This MP goes on to say, "And as such, we have to recognize that there are going to be people in this public service world who come from different backgrounds and who the government interacts with, obviously, but that is a strength for our country. We look forward to inviting people from various sectors, in this case the business sector, but from all sectors, to make a future contribution to our country. Do you know who that member of parliament was, Mr. Blanchard?
I've read it, and I believe it's Mr. Poilievre, the leader of the opposition.
That's right. So my question is, if the leader of the current leader of the opposition believed that the law and the screen were appropriate in the case of the Harper government, should it not be good enough in the case of the Carney government?
I will leave it to a parliamentarian to debate this.
Okay, I believe it is. Thank you very much, Mr. Chair.
Thank you, Mr. Baker. Mr. Blanchard, Monsieur Thériault, 5 minutes.
Mr. Thériault, you have 5 minutes. Earlier, I was asking you about Mr. Wright, and I was saying that he was not a prime minister. My concern, as I mentioned earlier, was ensuring that we have different rules. Do you not believe that the highest level of governance requires the highest level of transparency? I believe that you're going to say yes. I would say that that's why Prime Minister Carney agreed with the Ethics Commissioner on these measures. He divested, put his assets in a blind trust, and agreed on the implementation of the ethics screen. And it includes companies on Annex A, and this is an exhaustive list because the Prime Minister understands his responsibility. Do you know who the trustee is? No, I do not. Only the Ethics Commissioner knows. No, I believe that it was chosen by the Prime Minister and the Ethics Commissioner. The lobbyist registry indicates that on from July 10th to today, 2,600 lobbyists were registered for doing lobbying with the Prime Minister's office, 150 communications between lobbyists and PMO, and 75 between lobbyists and Mr. Carney. Communications with lobbyists and communications between PMO staff and Mr. Carney, and once staff has discussed with lobbyists, is there any kind of surveillance of these communications? As I mentioned, there's a rigorous process in place for managing meetings with the Prime Minister. If a meeting is requested by a company that is on the list in Annex A, well, no meeting will be organized. Also, we ensure that there are no discussions during those meetings that would have to do with a company listed in Annex A. There are no meetings, but you decided not to use the screen, or did not ban Mr. Carney from speaking with these people. Mr. Carney understands his obligations. Yes, that's the response of a chief of staff. You play your part very well. That's not the response of somebody who has to apply an ethics screen. And yes, that is my opinion. I respect your opinion, but I don't share it. Because there are processes in place. There are no meetings, no discussions. The screen is applied in that way. But your logic, well, you're saying there needs to be a blind trust, but when you say he understands his obligations, you could have said, well, no need for a blind trust. He understands, and he'll never be in a conflict of interest. This logic that you're trying to share with me, that's how it is perceived. And if you're not banning meetings, well, the PM can take out his cell phone, and if you're not surveilling it, or perhaps if you're ensuring some oversight and you're telling him, well, be careful, but you're saying no, he knows what he has to do. Is that truly responsible, a responsible way of acting? The process is very rigorous, Mr. Thériault. I'm not saying that you're rigorous or not. There are no meetings, and if there are meetings, certain topics are not raised, and in his office it is managed, and people receive training so that they can ensure that all of the obligations are met. Thank you. Time's up. Mr. Barrett.
Mr. Blanchard, yesterday the clerk told us that he sold his Brookfield shares within minutes because he couldn't oversee the Prime Minister's screen while still holding them. Why shouldn't the Prime Minister meet that same standard and simply divest by selling his assets instead of holding them and the potential continuing for him to benefit financially from decisions that he takes in his role as Prime Minister?
I believe that the Prime Minister, what has been set up for the Prime Minister is actually the highest level of standards of ethics. First, there's a divestment of all of his assets. And second, there is actually, he has agreed with the Ethics Commissioner that for a list of companies that are listed at the Annex A of his public declaration, that there would be the possibility, when needed, to establish an ethical wall. These are very rigorous, as I've been explaining now in front of this committee. We have a rigorous assessment tool. We have a rigorous process, and actually it is working, and it's been used in the past. And this is, I actually believe that this reflects the highest level of ethics, and also that the Canadians see that as a very transparent way of doing it. Actually, I've shown you courts are in agreement with this, that this way of doing things is more transparent to Canadians than any other choices we could have made.
Do you think that it's more transparent than if the controlled assets were sold before the Prime Minister had the opportunity to make any decisions? Do you think that having them in this process that needs to be administered is more transparent than him simply divesting fully of it?
Actually,
that's
I think
question.
it's very transparent on the part of the Prime Minister
But is it
to have
more
accepted to be.
transparent,
I think it's very transparent on the part of the Prime Minister to have actually gone through the divestiture of his assets, putting it in a blind trust, and actually going into and agreeing and convening with the Ethics Commissioner to set up an ethical wall for the companies listed at Annex A, and ensuring we are working with him to ensure that the process is well respected, and that he respects the highest level of ethics. And that has been actually, it's a practice that the OECD recognized as being one of the best practices in the world in this matter.
And so you used the phrase, one of the best. And my question to you is if we can improve on it. And so I think that Canada has the opportunity, and that's the study that we're undertaking at the committee right now. Can we improve on the system that we have? Are there concerns? Are there loopholes? Are there things that are giving rise to Canadians' loss of confidence or lack of confidence in our democratic institutions? And so we have an opportunity to improve on it. It doesn't necessarily serve as an indictment against Mr. Carney, but is there an opportunity? I appreciate your reference to how it's been used in the past. I appreciate your reference to the federal court ruling. That's important context and serves well to inform the evidence that this committee will have in taking recommendations forward to the House. But is this the best way? Canadians understand that if a Prime Minister, if Mr. Carney owns assets, controlled assets, even if they're in a blind trust, and if he knows what he put into the funds that he stands to benefit from through interest payments in the future, and the decisions that he and his government take improve that portfolio, well, he's going to profit from the decisions that he takes. So if he owns it, the potential for him to financially benefit continues. Wouldn't it be cleaner? Wouldn't it be simpler? Wouldn't it improve the confidence that Canadians are able to have in the process if the requirement was for prime ministers and for party leaders, including the leader of the opposition, to sell all controlled assets, and then if there were investments to be made, the discussion could be had on if a trustee could make those, but perhaps they don't hold controlled assets while they're in office. Wouldn't that just simply eliminate the risk and thereby solidify and actually improve Canadians' confidence?
I'm going to have to take that as a statement, Mr. Barrett, because we're 15 seconds over. If you want to return to it later, you're more than welcome to do that. Mr. Maloney, 5 minutes.
Thank you, Mr. Chair. Thank you, Mr. Blanchard, for being here. I'm sure you've had more productive uses of your time than being here for this 2 hours, from what I've heard so far. I'm going to start with something Mr. Cooper said. He started by saying Mr. Carney's conflicts are vast, and then he ended by saying, wouldn't it be better if the PM just heeded the advice of the Commissioner? In your opinion and the opinion of the others who are involved in this process, has the Prime Minister heeded the advice of the Commissioner and followed the rules?
At all time that I'm aware of, the Prime Minister has actually s'est engagé et s'est conformé aux.
He complied with the recommendations made by the Commissioner.
Has accepted the advice of the Ethics Commissioner and has complied with it. And this is one thing. The other thing is, I want to say that what has been agreed upon between the Commissioner, the Ethics Commissioner, who is an independent public office holder, like that he is an officer of the Parliament, and everything that, you know, what he has proposed, the Prime Minister has agreed, and we have a very extensive process to ensure that we prevent any, as much as we can, and any possibility of conflict of interest.
Thank you. And something Mr. Barrett said, other than this not being an indictment of the Prime Minister, he suggested when he asked his first round of questions, and he just did it again, that he suggested that you put these assets in the blind trust, and then you could then subsequently act to benefit the blind trust. The fact of the matter is, when assets go into the blind trust, you no longer know what happens after that. The assets could change. The structure of the trust could change because the trustee is now responsible for that. Is that right?
Yes, it is. And that's what actually Nigel Wright was saying in his testimony. And this is why I quoted Mr. Wright, because I thought it was the assessment of the reality. And this is what is happening. Mr. Carney has divested of his interest in a blind trust. He doesn't know now. It's actually not to him to make any decision in relation to these assets. The decisions are made by a fiduciary and a trustee. And then on top of that, he has accepted, the Prime Minister has accepted this ethical wall to ensure that we prevent any possibility of conflict of interest.
Thanks. And we know that Mr. Wright was always going back to Onyx. In fact, he went back to Onyx while Mr. Prime Minister Harper was still in office. So to try to distinguish the two is a bit of a false narrative, in my opinion. Would you agree with that?
Well, it was certainly a difficulty for the ethics, for at the time of the committee, the fact that Mr. Wright wanted to go. He wanted to go back. He was just on a congé sans solde from Onyx. He kept all of his, in some ways, he kept a lot of his relationship with Onyx, which is not the situation of Mr. Carney with Brookfield.
All right, thank you. And Mr. Majumdar suggested that there's a cloud of uncertainty and conflicts. I would suggest that's not true. In fact, what there is just a flurry of allegations. In fact, if you look at this study The original purpose of this study was principled. It's to review the Conflict of Interest Act, including the Conflict of Interest rules. That's a noble, principled approach to what we should be doing as members of Parliament. However, the reference from the House of Commons amending it suggests that it include consideration based on the unprecedented extent of the Prime Minister's corporate shareholders' interest. I'm not sure what the word unprecedented adds to that. If you're talking about a Prime Minister who's had success, I don't understand. I'm suggesting to you, and this is what I would like to know if you agree with me or not, that this is purely a political exercise. We should be reviewing in this committee the Conflict of Interest Act, not trying to fire off random questions about the Prime Minister or any other member of Parliament in the hope of scoring some political points, which have not been made. Would you agree with that?
As I said before, I happen to agree with you, but I leave the political game to all of you parliamentarians.
Okay, thank you. And I'll leave it with, I'll end with this. You were the CEO of McCarthy's law firm, one of the biggest, if not the biggest law firms in Canada. As a lawyer myself, I understand conflict of interest are important. As a multinational, multi-provincial firm, you were in prime position to review the conflict of interest provisions in your office. And if you're wrong, you get sued or you get sanctioned by the Law Society. So the last thing you want to do in that position or as a Chief of Staff to the Prime Minister is get into that situation. Isn't that right, sir?
I totally agree.
Thank you. Mr. Cooper for 5. Go ahead, sir.
Mr. Chair, Mr. Maloney and Mr. Blanchard can say all they want that the Prime Minister has satisfied the threshold and the standard set by the Ethics Commissioner, but I would refer to the testimony from yesterday when Mr. Sabia, the clerk of the Privy Council, was asked, will you say to Mr. Carney that he can no longer speak with Brookfield? Answer from Mr. Sabia, it wouldn't be necessary for me to do so. In discussing things with the Ethics Commissioner a few months ago, the Commissioner told him to do just that. In other words, don't talk to Brookfield. What did the Prime Minister do instead? He met with Sam Pollock, the CEO of Brookfield Infrastructure in Washington. He was lobbied by a company that is owned by Brookfield, and he had a private breakfast working meeting with 4 Brookfield investors in London, hardly following the guidance of the Ethics Commissioner. Now, I want to pick up on a line of questioning for Mr. Majumdar about who is screening who. In that regard, do you screen Mr. Carney's texts?
Alors, je voudrais répondre à votre question, M. Cooper, sur...
I'd like to respond to your question, Mr. Cooper, on meetings. For the meeting that you referenced...
Mais je pense que c'est important que je réponde à votre question.
But I think it's important that I answer your question.
A yes or no answer.
Je vous réponds.
I'm going to ask you, Mr. Blanchard, to answer Mr. Cooper's question, please.
Ma réponse, c'est que la rencontre à laquelle M. Cooper fait référence...
For what Mr. Cooper is alluding to, a meeting between a company that belongs to Brookfield and Mr. Carney did not happen.
Mr. Carney's texts, yes or no?
Monsieur Carney, the Prime Minister has set for himself the highest level of ethics.
So I take the answer is no. Do you screen Mr. Carney's phone calls?
Vous répondrez que...
Yes or no?
Monsieur
yes or no?
Point of order, Chair.
Point of order. Mon rôle...
Hang on. Hey, Mr. Cooper, you're going to have to give Mr. Blanchard a chance to
These
answer.
are yes or no
and I would prefer, I would appreciate...
He's repeatedly obfuscated.
Monsieur...
Quite deliberately so.
Mr. Blanchard, please answer Mr. Cooper's questions.
Il y a un bureau qui entoure M. Carney. Et il y a
There's a whole office that works for Mr. Carney, and there are people who work with Mr. Carney, and they receive training in order... Can you let me respond?
So I'm going to ask you this. Who screens Mr. Carney's texts and phone calls?
Alors,
it's a simple question.
Mais vous savez, il y a des gens qui travaillent avec M. Carney dans son bureau exécutif qui ont reçu la formation pour s'assurer que les mesures éthiques soient appliquées.
Hang on a second. So we don't have translation. So I've stopped the clock. We don't have translation. Do we have, est-ce qu'on a, si je parle
Can you
en
hear the interpreter now?
Translation is back. I'm going to get you to ask the question one more time. I'm going to get you to respond, Mr. Blanchard, and when Mr. Blanchard starts responding, I'm going to start the clock.
So you don't screen Mr. Carney's text, you don't screen his phone calls. Who does?
I didn't say that.
Well, you wouldn't answer.
I did not
You wouldn't
say that.
answer yes
I
or
did
no
not say-
questions. They were
What?
yes or no questions. So you refused to answer.
It's
so
not a
I'm
yes or no
inferring that
question.
you
I'm sorry, Mr.
simply
Cooper.
don't.
It's
so you
not,
do?
Mr.
Point of
Cooper.
order, Chair.
It's not an
You do?
yes or no
Mr.
question.
Cooper,
please.
hang on a sec, okay? Just let him answer the question, please, Mr. Cooper, and then we'll go back to you. Go ahead, Mr. Blanchard.
Pardon?
Okay, I got a point of order from Mr. Fergus. Go ahead.
I think the reason why the translation is going off is because there's talking over each
Yeah.
other. So it'd be very important for the questioner to ask this question alone and for the speaker to answer
I
the
made
question
that
alone.
point. I made that point earlier, and I asked that it be respected for the sake of the interpreters. That when you ask a question, make sure that there's a clear answer that's given, and then you can go back to the question. Please don't talk over each other. Mr. Blanchard, à la question, s'il vous plaît.
Ce que je veux, la réponse est plus.
The answer goes beyond a yes or a no. There are people around Mr. Carney who field calls for him. Those people receive the training, and that's one of the measures to ensure that he respects his obligations.
Vague answer to a very straightforward question, and that is who screens Mr. Carney's meetings, phone calls, and texts?
For the meetings.
I misspoke. Phone calls and texts.
Alors, je vous ai dit, je vous ai informé que
I said that there's a team of executive assistants that have received training, and they can ensure that we meet the ethical requirements that the Prime Minister is committed to.
No one screens his texts or phone calls, and therefore I would submit there's absolutely no assurance that Mr. Carney isn't in touch with folks from Brookfield, of which he has vast conflicts of interest, and others. You simply haven't provided any indication that anyone screens anything as far as his texts and phone calls go. I want to ask you, Mr. Chair.
10 seconds, 10 seconds.
Well, okay, I'm out of time.
Okay. Mr. Turnbull, for 5 minutes, go ahead. Et après ça, M. Thériault, je vais donner 2 minutes et
And then,
30
Mr.
seconds.
Thériault, you'll have 2 minutes and 30 seconds.
Great to see you. Want to start by asking you a similar question to Mr. Maloney about blind trusts. Obviously, the Prime Minister, in order to be in a conflict of interest, must be able to make decisions to further his own private interests. The whole point of a blind trust is that he has no control over those assets. So essentially, all of the assets that he's divested into that blind trust could have been liquidated, could have been reinvested somewhere else. Do we, any of us, really know what's held in that blind trust at this point?
outside of the trustee and the ethics commissioner, I'm not aware of any other people that would know this. And this is in accordance with the law and the obligation that are flowing from the ethics and.
Okay, yeah, I appreciate that. And we've heard from the testimony going back to Nigel Wright about the whole point of it is that you don't know what's in there. We've heard from witnesses in this committee, the professor at York University who said there was a public office holder who later found out post holding office that there were investment decisions that they didn't agree with. They were disappointed, but they didn't know. That's the whole point. The other point of this is it seems that the process is blind on two sides, in a sense, because the Prime Minister himself also does not administer the screen, the ethics screen that you've been describing for us. So in fact, that screen is managed by yourself or administered by yourself, the clerk of the Privy Council, and overseen by the Ethics Commissioner. Is that right?
Yes.
So essentially, every decision that the Prime Minister could make is something that you three are reviewing, or that you, the two administrators, the clerk, and yourself are reviewing?
Yeah, I mean, we are by the virtue of our function, we actually have views of it. On voit le processus et on est au courant.
We are very aware, and that's how we can act in a preventive manner and ensure that there is no conflict of interest for the Prime Minister.
Or making any decision that the Prime Minister has already covered and these potential conflicts have been screened out.
Yes, that's the entire process. This is the goal of the entire process.
And this has been overseen by the Ethics Commissioner, who has been satisfied with the level of rigor of the implementation.
Yes.
And the Federal Court of Appeal has ruled that the conflict of interest screen was an appropriate measure.
Yes.
I guess, our Conflict of Interest Act has a very high standard because it says not only that the Prime Minister must not, or the public office holder must not, get into an actual conflict of interest, but also must protect against a perceived conflict of interest. In essence, with the fact that these two, both the blind trust and the independent administration of an ethics screen, as you've described, doesn't it make it almost impossible for the Prime Minister to be perceived of being in a conflict of interest?
For any potential and real conflict of interest, actually, I agree with you.
Okay. Well, I appreciate your testimony here today, and it seems to me that this is a very rigorous process. You said at the very beginning in your opening remarks that this was the most rigorous process that you've seen in your career. You were Canada's representative to the United Nations, you were Executive VP in charge of Global Division at CDPQ, and you were Chairman and CEO of one of the largest law firms in the country. And you're telling us that this is the most rigorous that you've seen.
And the reason why I say that, it's actually because it's the number of people that are, how pervasive it is in the system, in the bureaucracy, in the political side, that actually so many people are aware of it, are sensitive to it, and are raising the flags at the right time. This is really what is the rigor of this system.
I'll just make reference to, in my past, many moons ago, I was working in medical research ethics for a while. And the highest standard in medical research ethics is something called a double-blind research trial, right? This seems to me to apply to this moment because there's essentially a double-blind here. On the one hand, the Prime Minister is not controlling the ethics screen, and on the other hand, he's not in control of the assets that he once held.
And he's not aware when we screen something. That is actually a very important point.
Thank you. Monsieur Thériault, 2 minutes 30 secondes, suivi
You
par...
have 2.5 minutes and 2.5 minutes for the Conservatives and 2.5 minutes for the Liberals. You have the floor. Thank you, Chair. The Ethics Commissioner would like to introduce into the legislation the appearance of a conflict of interest. I know you didn't want to respond to that earlier, but I would say that in situations like the one that we find ourselves in, there should be more efficient proactivity for the Prime Minister than what we currently have. And I'm still reflecting on the highest degree of transparency for a Prime Minister. Paul Martin, who put in place the commission on the scandal, had higher standards, and when he was a minister, he had kept his boating company. But when he became Prime Minister, he sold it. And this brings me to my first question, the one that I asked to Mr. Sabia yesterday. Would your life not have been made easier if Mr. Carney had been as exemplary as Mr. Martin? Mr. Carney is exemplary because he divested and put his assets in a blind trust. But a blind trust, I mean, when we look At C5, I don't know. I wouldn't know how much my fortune would be increasing by, but as a businessman and a finance man, I would know that my fortune would be increasing. I don't share that opinion. The Prime Minister divested, put his assets in a trust, and then decided on a screen with the Ethics Commissioner. You keep saying wall in French. It's not a wall, it's a screen. Well, I think it's more of a wall. And it includes the list of companies in Annex A, and there is a rigorous process for the implementation of this screen. Rigorous? Mr. Carney meets the highest standards. Well, it's not without issues. Will you ask Mr. Carney to recuse himself from the vote on C-15? The vote on C-15, well, the screen would not apply with C-15. You need to review your tool then, Mr.
With time for a response from you, I assure. My question at the end of my last intervention was with respect to improving on the Act as it exists now, and improving Canadians' confidence that they're able to have, and simplifying, if I may, by having prime ministers sell all of their controlled assets before they take any decisions. And the challenge that we see in this specific instance is that there are things that the trustee cannot trade away, like the carried interest that the Prime Minister is entitled to based on the performance of some of the Brookfield assets that were placed in the blind trust. Even if you set aside what the Ethics Commissioner said, and that oftentimes there's very little churn in these trusts, and some things just will simply be managed but not traded. Do you think that I understand that you said that you like the system, you believe that the current system is effective? I appreciate that. Do you think it would be an improvement on the current system to have prime ministers sell their controlled assets before they take decisions?
Actually, I believe that at the moment, this requirement of having that they divest from their assets and put it into a blind trust is, to me, is a divestiture in itself. The Prime Minister has no knowledge of what has happened at this time. He has no knowledge of what has happened to the assets that he divested himself from and put in the blind trust.
So we have just about 30 seconds left, but there are things that are in the trust, or there are future payments that the Prime Minister is likely entitled to, this carried interest that I mentioned, for example. So that benefit still exists, and that isn't resolved by the blind trust. So again, my question is, wouldn't this be an improvement upon the system that we have?
Dans ce contexte-là, premièrement, je suis pas au courant de ce qui est dans le...
I am not aware of what's in the trust. And coming back to the premise of your question, the Prime Minister divested, put his assets in a blind trust. This is a system that is recognized throughout the world as being a good one, and then it's a good way to manage such cases and allows an elected official to meet the ethical requirements. Thank you.
2.5 minutes.
Thank you, Mr. Chair. Mr. Blanchard, one of the purposes of the Act that is explicitly outlined is to encourage experienced and competent persons to seek and accept public office and to facilitate interchange between the private and public sector. It's in the very heart, the very purpose of the Conflict of Interest Act and the regime. We heard from Mr. Sabia yesterday, too, that this is important from his perspective, not only for MPs and elected officials, but also for recruiting to nonpartisan public service roles as well at the highest levels. In your vast experience across private and now public sector, do you see this as an important purpose of the act, and what can we, and how does it contribute to being able to encourage people from diverse backgrounds and from private sector backgrounds to step up and undertake public service?
I think it's a very good question, and if I may, being someone who believes that the public service is the highest form of service we could do, and I deeply, deeply believe that. So I congratulate and thank every member around the table to do this. It's a tough job. It's demanding, but it's so important. And I think it's going to become more and more important. The situation we're going through at the moment is historical. It's unprecedented from, like the clerk yesterday said, since World War II. But important decisions needs to be made. And more decisions involve the necessity to actually have the public service and the public sector work with the private sector and all stakeholders around to make sure that we can make things happen, that we can deliver. The biggest issue to me, in my mind, for our institutions is our ability to deliver what the citizens need in this environment. It's about delivering services to citizens, and this is what is the biggest threat to our institution, is the perceived inability to deliver to citizens. And this is where, whatever you conclude, Mr. Chair, and the work in this committee, I think it has to be that you make sure that we encourage the interchangeability and that actually it happens more and more rather than less and less.
Thank you, Mr. Blanchard. Thank you, Ms. Church. Mr. Blanchard, on behalf of the committee, I want to say thank you for your time today. I know we had to work out the schedule, but we did. I also want to thank the clerk as well. I know, Nancy, that putting this meeting together was difficult, and I appreciate all the effort that you did to get the technicians and everyone in place. So I have no other business. This meeting is adjourned. Thank you.